Ms. Garber.
Thank you. Members of the Council, I'm going to give an EIR update, which will cover in brief what happens between now and when the EIR comes back to you for certification. On November 30th, Volume 3, the recirculated volume of the draft EIR was issued for public comment, public review and comment for a 45-day period. Volume 3 evaluates the final draft Delta plan. The fifth staff draft was what the proposed project was that was evaluated in volumes 1 and 2, and this is called the revised draft Delta plan, or the revised project in this volume 3. I believe you have the executive summary of volume 3 attached to your staff report. I just wanted to talk for 1 minute about what recirculation means, because it's a term of art under CEQA. Recirculation refers to the process by which new information is made available to the public for review and comment after the close of the comment period on the draft EIR, but before the final EIR comes to you for certification. So it sounds like the word recirculation is a little confusing because it sounds like something you've seen before and it's being sent out again, but that's not what it means. It's just during this period before you certify the EIR, if you want the public to have a chance to look at and comment on some new material, you circulate it for public comment. As Mr. Stevens said, the public has been requested to focus its comments only on Volume 3, and that's a process that's authorized under the CEQA guidelines. What Volume 3 concludes is that while the environmental impacts of the revised project, the final draft Delta plan, will not differ substantially from the project that was reviewed in volumes 1 and 2. While there will be more construction projects, which because there'll be more construction impacts, because there'll be somewhat more construction projects encouraged by the final draft. And so there'll be more short-term construction impacts. There will be longer-term, more long-term environmental benefits. Therefore, this volume concludes that the revised project, the final draft Delta plan, is the environmentally superior alternative because it is the most effective in arresting or reversing the decline in environmental conditions in the Delta. It does more to reduce reliance on Delta water supply and improve regional self-reliance. It encourages more projects to improve water quality, and it does more to limit agricultural land conversions than the prior version of the proposed project. The rest of the EIR process consists of, after the close of the comment period on January 14th, responding to comments, all the comments, both the comments received before and any new comments, preparing the final environmental impact report, which will include the responses to the comments, and presenting the completed EIR to the Council for certification and for consideration in its upcoming decision on the Delta plan. As we've just discussed, the Council's received several letters requesting an extension of the comment period beyond the required 45 days. There is no legal requirement to extend the comment period. And as a practical matter, this volume is quite a bit smaller than what was circulated before. It's about a quarter of the size, is my understanding. I haven't counted the pages, but it is being recirculated because the project has changed, but it's changed in ways that involve a substantial reorganization and some new policies, some new recommendations, some policies.
A reorganization of
the Delta plan.
Okay, so the changes in chapters and
changes in
material
chapters,
moving between chapters and so on.
Yes, and some new background information, edits to many of the policies and recommendations. Some policies are still there, but they are now recommendations. And because of the overall number of changes, although none of them in themselves turn out to be significant, there's a substantial number of them. That's why a recirculation was a prudent course of action. There are no other unusual circumstances bearing on the comment period. Although there are holidays, the volume wasn't issued until after Thanksgiving. There is the holiday period coming up, but then there's 2 weeks after New Year's. The comment period doesn't close until January 14th. So those are the practical considerations in addition to the legal.
Yeah, Ellen, just a question. Comments can be in writing. That's the preferred approach. However, if I'm not mistaken, oral comments at a public hearing, whether it's today or at another session, can also be included, and if they're properly, presented, they need to be responded to as well, or unless this is different. Does everything have to be in writing, or if somebody spoke today or at a subsequent hearing prior to the close of the period, those oral comments count just as much as the written comments? Is that correct or not?
That's correct. There is no requirement to hold a public hearing under CEQA. Nevertheless, if oral comments are submitted before you during the comment period, it would be prudent to respond to them because they would be pertinent and they would be during the comment period.
But then, and that goes to my point, we'll get to this a little later on in the conversation about that actually the only opportunity to do that orally in order to make it for publication date. I mean, you can still do that on the final draft, and when it comes for this body for final certification, those comments can still be taken into account. Again, I'm doing it for my other life, but having spent a lot of time yesterday going through environmental document, is pretty. Some of those things were reminded to me as the process. So I guess my point is, though, is that today, because of our meeting schedule, is really the only opportunity in this setting to make those oral comments, and that's where you receive them. You can't do that. They can't come to you or to Chris and say, well, this is my comment. Then you need to put it in writing. So, again, with no requirement to have a public hearing, this is it. I mean, before the published period of time expires, and unless we were to extend it to our meeting in January or have a meeting prior to the close of the comment period. So this is basically the only opportunity to do that orally. And people may not choose not to do that anyway, but I mean, it's a valid approach, and I guess that's the point I was making earlier, and that's why I was asking the question about the extension, not for a period of weeks or months, but even a matter of days would give an opportunity for folks to comment before we close the formal period. Doesn't preclude them from commenting between then and when this council would have before for final action. So.
Sure, and I think that's accurate. In my previous comment about making comments at this hearing, what I was suggesting is that oftentimes it helps both the commenter and the council and council staff to really address the comments thoroughly if they come in writing. So I wasn't trying to dissuade anybody from talking about the substance if they wanted to at today's hearing. I just wanted to make note that we don't have a court reporter, but if somebody wanted to make an oral comment, that would be perfectly appropriate, and it would be, as Ellen said, prudent for us to respond to that as well as all the other comments we received. Thanks.
Any questions, Ms. Garber? Any questions? Okay. Who's up next?
Okay, so we have Steve Hatchett, who's going to walk us through the rulemaking process package presentation.
Okay. All right. Thank you. So the rulemaking package that you have in your larger packet includes a number of documents. I'll briefly step through some of those and then focus on what's really the new piece of analysis that is provided as part of this is what's called the economic and fiscal impact statement. So I'll give a little bit more attention to that. So briefly, this package was filed with the Office of Administrative Law, which is the state agency that kind of sets the rules for how this rulemaking process works, at the end of November, and it was published on November 30th in their register. So that initiated the 45-day comment period that we've been discussing. As part of that package, of course, it includes the proposed regulation itself that is a fairly long, I think, as far as regulations go, but I did want to point out that the majority of that are appendices that are needed for reference by the sort of the main body of the regulations, which are, and this is important for you to keep in mind, so the regulation that we have here is basically the consistency process and the policies from the Delta Plan. So I think in most cases it's verbatim. There may be a few cases, Chris, where there needed to be some clarifying language inserted just because those policies were pulled out of the larger context of the Delta Plan.
Yeah, I think
So-
that's an important point,
Right.
Steve. None of what you see in the actual draft regulation should come as a surprise.
Right.
It's almost all verbatim.
Right. And so that part of it is only 16 pages. It's not 90. The rest of it is required information because those policies relate and reference other sections, appendices, and so forth within the Delta Plan. So the rules of that OAL has said gives you the choice of incorporating those appendices by reference and not incorporating them explicitly, or the way we've chosen to do it is extract the needed pieces and put them in as appendices formally into the rulemaking, into the rule.
So the point of the Office of Administrative Law Review is to make sure that regulatory agencies have regulations that are grounded in the statute. Is that correct? And not inconsistent with the statute?
That's one of the things that when we get to the at the current moment, it's basically in your hands right now as sort of the drivers of this process for the review and
Right.
responding to comments. Once that's done and it's submitted as a final proposed package, that's the point at which the OAL really digs. They did some initial review to make sure all the pieces were there, but that's the point at which they will address that point, whether it's whether you have authority to do this, whether it's consistent or inconsistent with existing laws, clarity, whether it's clear to the regulated entities what's being asked of them, those kinds of things. That will happen later in the spring when we submit the final.
So what we're all doing is in anticipation that OAL, which is the body that looks at it, is to make sure that when we get to their doorstep, we give them a document that they view as consistent with the law and clear. That was another criteria,
Yes,
right?
yes.
So those two, what other central things do they look for?
Oh, there are 6 or so of them. I'm not going to be able to come up with all of them on the top of my head. It may be there's another document that was provided in your packet that is actually from the OAL that perhaps lists those, but I can get those
So it would be fair
to
to
you.
say, though, or maybe Chris, that, clarity is harder to measure because clear to whom, but so they might have suggestions for revisions to make something clearer or so forth. The real authority is to say whether you're consistent with the law or you're essentially making new law or offering an underground regulation, something not grounded in the law, right?
That's right. And great questions. I wanted to point out that as an attachment to the staff report, we've taken the liberty of including some documents that OAL actually has on their website. It's an abstract from something called How to Participate in the Rulemaking Process. And I think we've attached 9 or 10 pages. It includes 2 flowcharts that are relatively informative. The second piece of the flowchart actually goes to the OAL review questions that you're asking about, Pat. The APA standards. This is on page 8 of the handout, or the OAL handout. What they're looking for: authority, reference, consistency, clarity, non-duplication, and necessity. So you basically have to make the case for not only the fact that you've got authority to do what you're doing, but that there's a problem and a purpose for the regulations in the first instance, then that the regulations that you're adopting have a rationale and a basis and are actually accomplishing the need. They're focused on the purpose. They're clear in how they're drafted so the regulated community understands what's being asked of it. Non-duplication just means that you're not reinventing state law. And what OAL will do once you have adopted your regulations and sent over your final rulemaking package is they'll have 30 days to make their finding to approve the rulemaking package based on these standards. And what they're doing, and an important point, is that they're not looking so much at the substance of your regulations. They really do have a checklist where they go through and look at these 6 things. And if there are problems, they'll get back to you, and hopefully you can work them out ahead of time. But without putting the cart before the horse, I think the process is here. It's laid out. It's relatively clear, and it includes, as I said before, what this council is going to hold on the 24th of January, which is an actual hearing dedicated to the rulemaking process, where we'll have a court reporter and members of the public will be invited to come up and testify on the substance of the rules and to go to these 6 points, which will be part of the rulemaking record that we ultimately ship over to OAL.
Mr. Natoli, and then Ms. Gray.
Just a question. So is the 45-day rulemaking period running concurrent with the 45-day comment period on the EIR?
That's right.
And so technically, though, then you will have closed the comment period on January the 14th for rulemaking, and you had to have the public hearing on the 24th. Would it make some sense to keep the rulemaking comment period, and we'll have this discussion about at least for that 10-day period, open during that time? Otherwise, you get this gap. You close the formal comment period on the 14th, and yet you, I guess, reopen it or whatever that constitutes. I mean,
Right.
You have it open on the public hearing. Why wouldn't you do the public hearing during the open time for the public comment period?
That's the way that it's actually set out in the Administrative Procedures Act, and that's typically done in these cases. So you have a 45-day written comment period, and that closes.
Okay.
And then the opportunity for an oral comment period. You can also submit written comments at that hearing, but that's just the way that it's
But the
set
hearing
out in
typically is
law.
after the comment period?
It's after the written comment period closes. And again, there is no requirement that an agency holds the separate public hearing unless a member of the public asks for it, although an agency such as ours that is founded on transparency typically holds one anyway.
Sure.
So.
Okay. Thanks.
Ms. Gray.
Suppose there's a major problem with one of the regulations with the meeting criteria. What does that mean?
Well, it means that when we send it over to the Office of Administrative Law, they're not going to approve your package, and they're going to point out the difficulty. And typically, an agency can go back and revise ancillary documents, statements of reasons, supporting documents that clarify and that refine what the justification for the actual regulation is. Oftentimes that helps. If you actually have to go into the substance, the body of the regulation, that may entail another 15-day period whereby you can't adopt or resend until you've given the public a chance to comment on the change. But typically, OAL will work with an agency to make the refinements that are necessary without having to change the substance of the regulation, absent some fatal flaw. I mean, if the regulation isn't founded on authority, if it's an agency that goes beyond the bounds of its authority, then you've got a problem that you've got to work out.
It doesn't delay the actual adoption of the plan, does it?
Well, it's going to delay the effective date of the operative parts of the plan, and depending on the significance of the issue, the council may or may not want to reopen discussions on the plan. But again, we're talking in a hypothetical scenario that hopefully, if changes are required, they're going to be minor refinements. But it happens. There's a process built into the end part. You'll see in the flow chart that we've attached, whereby if OAL disapproves a package, there's an opportunity to go to the governor's office for an appeal. But still, you have to make the case that you actually do have authority. There is clarity. It's just OAL got it wrong. The governor's office can overrule that. But so there's a process to work at. We're not there yet.
But the reason you don't want that to happen is when we get sued, we want the Office of Administrative Law to say we vetted it and we approved
Absolutely.
it, as opposed to having a political decision
Oh,
by the
yeah,
governor.
absolutely.
I would just add to emphasize a point that Chris made, is that because the regulation is the set of Delta Plan policies, a substantive change that might result from OAL saying, well, this particular policy just isn't clear for purposes of regulatory law. I suppose the council could decide to live with that inconsistency between what it has to say in the regulation versus what it says in the Delta Plan for some period, and maybe just come back later and amend the Delta Plan to bring them in consistency. But that's an implication of having a change like that.
Okay.
All right. Very briefly, the pieces that are in the rulemaking package, the notice of proposed rulemaking. That's the notice that went out far and wide.
This is agenda item 7B of your packet.
It
Of
could
our
be.
packet.
I don't have the list
Yeah,
in front of me, but yes.
Staff memo on this subject is in our packet.
Okay. And it's basically a summary description includes some of the findings in the fiscal impact statement and so forth. I've already talked about the proposed regulation itself. The initial statement of reasons is really where the agency makes its case, as Chris was describing, as to why the regulations are necessary, how they're related to the authority that the council has. And it also requires that alternatives be discussed. So we've discussed those in two different ways. So there's a general discussion of the EIR alternatives, but we were careful, and that's still in process, so there's no language that sounds pre-decisional there. But then we also looked at it on a policy-by-policy basis and tried to reflect sort of the options, if you will, that the council considered as it went through the 2-year process of developing the Delta Plan, and why the proposed policy looks the way it does as opposed to those alternatives. So. All right, the economic and fiscal impact statement, it's also well known as Standard Form 399, and I think I have it here. If it's this standard-looking form in your packet, is what the Department of Finance will take and review once the final rulemaking package is ready. So the OAL will take other pieces and review them according to those criteria. Department of Finance will take this and review it. So let me just very briefly step through. Actually, maybe it's better to just sort of give some overall concepts that are important as we were developing this economic and fiscal impact statement. So the first is that it's not intended to be, and it is not, a benefit cost analysis. So there is some discussion, narrative discussion of benefits, but in the context of this kind of broad set of policies, it's really not plausible to quantify benefits as you would need to in a formal benefit cost analysis. It's more of state policy as provided to you by the legislature as part of the Delta Reform Act and that you have tried to implement. So it's not that, but it does have important components that are at least described and quantified to the extent that there's a reasonable way to do that. Another important point is that this only considers changes in costs to private entities and to local governments that would occur because of the Delta Plan. So anything that was already in place in existing state law regulation, federal law regulation, that you have simply sort of adopted and added a consistency consequence to, is something they would already have been doing were they complying with the law. So in those cases, our conclusion is it's not the responsibility of the Delta Plan to take account of those costs as its effect. It is the responsibility for the consistency process and any additional requirements that might have been layered on as part of that. So an example of that is in WRP1, for example. It lays out consistency, including adoption and implementation of water management plans by local agencies. Well, that's already part of state law. So that part of it is not the responsibility as a cost for the Delta Plan. However, there is an additional piece that was added to those that was demonstration of reduction in reliability, I believe it was. So we made
reliance on the Delta.
Yeah, we've made a reasonable attempt to assess what that might add to the cost of preparing those plans. So another general consideration is that the costs, what costs that do result from the Delta Plan are initially imposed on, let's call them sponsoring agencies, the local or state agencies that would be coming forward with the consistency process. However, those, we argue, are in some fashion largely, if not totally, going to be passed along to those agencies, customers, ratepayers, taxpayers, et cetera, in some form. So we have included those portions of the cost, and it's a large portion, in the economic and fiscal. So there's two sections. There's economic impact statement and then fiscal impact statement. So if you thumb through that form 399, you'll see it's the first part of it is economic, and it's asking what effects on private businesses and individuals. And then the second part is the fiscal impact, where it's asking what are the effects on local governments and state government. There are some numbers in there that show up in both places because we've made this conclusion that the costs imposed certainly on local governments would in some way have to be passed through. They have to recover those costs, and they have mechanisms by which to do that. And part of what we've laid out in some of the associated material that is in your packet is a listing of the various authorities that local governments, both cities, counties, special districts, have to pass through those kinds of specific or general planning level costs onto through assessments, fees, water rates, whatever. And then finally, I guess I just need to emphasize the uncertainty that was associated with trying to come up with numbers for this statement. We've had several discussions with the individual at the Department of Finance who will be reviewing this when the time comes. And so we've gotten some advice on, we're trying to walk a line between giving as much useful information as possible to people reviewing this and ultimately to the Department of Finance, but not being overly speculative to come up with a number. So what you're looking at in the 399 form is sort of the result of that struggle that we had. There's tremendous. We don't even know how many covered actions are going to come forward from year to year. So staff has made an estimate based on looking at recent CEQA filings and so forth, and we came up with a range, and so we've described that and used that as the basis for coming up with quantified estimates for at least some of the categories of costs. In addition to that, so the number we don't know, coming forward we don't know what they will be, how big they will be. So there's a lot of sort of layered uncertainty to come up with a final number that's what's being asked for in this form. And so in a number of places we came up with a number and it's in there, but in other places it'll say unknown or uncertain and see attachment 1. And so the form doesn't give us much room to work, so we have a 7-page attachment 1 where it really lays out why the entry in the form is the way it is, and then it further references a longer document of analytical work that you can go to see further explanation of how we came up with that. So in a nutshell, that's what the fiscal impact statement is, and there's some information in your staff report showing the kind of the range based on the assumptions that we have. There are specific questions that we've addressed, such as a housing cost, and there's a discussion of that and so forth. So maybe it's best to leave it there, and I can answer any questions.
Steve, okay. Before you get to questions, I just wanted to wrap up just a little about what the requirement is and then your interaction again with Department of Finance. Mm-hmm. So the fiscal, economic, and impact analysis is something that's required as part of the rulemaking process, and it actually has specified components that we have to address.
Right.
So I think Steve's touched upon all those in the staff report and in your nice presentation. It isn't a cost-benefit and a traditional cost-benefit analysis, which I think Steve touched upon as well. That isn't what's required as part of the rulemaking process. And it's important that we have been in contact with Department of Finance to date to get a sense of direction on whether or not we're approaching this right. Steve's point about the nature of the Delta plan obviously driving the type of fiscal impact analysis that you come up with is important because our plan has some indirect impacts. We're not quite sure how many covered actions there will be, what the nature will be. However, the requirements as part of the rulemaking package include coming up with costs to state and local agencies. So I think Steve's point is right on. Where we could identify those costs with specificity, we did so. And where we couldn't, we explained the rationale for why we couldn't or what the uncertainty was. And I think it's a balancing that I think comes through in the document.
Right, and even in those cases where we're not comfortable with coming up with a number or even a range of numbers, we've explained why and described the nature of the costs, and in a few cases even maybe use some examples of how it might play out for certain kinds of projects. But that's as far as we went in some of those cases.
And in terms of the process, then. Before we submit the final rulemaking package to the Office of Administrative Law, I think you mentioned that we will have to get the formal approval of Department of Finance as to this, Form 399
right.
and attached analysis. So we will actually have to get their approval, their signature. That'll become part of the rulemaking file that then goes to Office of Administrative Law, which we would be looking to make sure that we did get Department of Finance's approval
right.
as to the methodology and the contents.
Right.
Okay, Mr. Natoli.
Yeah, I want to thank you for certainly the detailed information. And I think it's important to point out, kind of from a local government perspective, the irony is not lost here that with regards to certainly legislation and the additional layers of authority in the land use area that's going to put regulations for covered actions on not only state agencies but local governments, and yet the strong emphasis on local authority to pass those costs on and be responsible for telling the customer, whoever that might be, that your fees have gone up in order to bring forward your proposal because it's lost. It's just that we charge the fee at cities and counties level, and I mean that may be how it worked. But again, in reading this, and this is not necessarily a criticism, it's the reality of certainly from where local government sits in the overall chain of command, and I guess in the food chain as well. And counties have a unique relationship with the state in a lot of respects. But we get a lot of that. And again, this is another example, and clearly it's following through on the law, the authority that's been vested in this council and its status. On the other hand, the whole thing about recovering costs, there are great limitations at the local level, and yet one of the ways obviously is that you build that into your permitting and construction permits and planning fees. But again, the irony there is that authority gets diminished in some capacities,
right.
and yet people are quick to point out how much authority local government has. You just go recover the costs, and it basically blankets what is embedded in law and requirements to do this, and it's just another added cost. And yes, there's the ability to recover that. And I can tell you, though, we get lots of pressure at the local level relative to what we charge and trying to remain competitive in the in the environment for people to actually do things that do contribute to I think to the betterment of a general locale, whether it be a city or county, not just in the Delta but throughout this state. And I wanted to point that out. I think it's important as representing for the Delta Protection Commission, cities, counties, and certainly reclamation districts and others that are involved. It's just a matter of fact of how things are structured, but I wanted to be clear to point that out because
and that was the purpose that we had also was to just make it clear that this is the likely mechanism that's going to and not our role isn't to take a stand on whether that is or isn't the right policy.
But Cindy is one who then has to pass on those fees, and here's the as a county supervisor, but my colleagues in other counties, certainly in other city jurisdictions, and even in districts that have certain authorities, are the ones that take the flak for, well, how come it costs so much?
Right.
Why is this process so long? Well, because somebody told us to do this. It may be the right thing to do, but you layer this on. This is just one more in a whole menu of things, and certainly other state agencies and private concerns in this audience and elsewhere, recognize some of those challenges. But I can just tell you that that's a constant pushback that we get. Why does it cost so much to do something as simple as get a permit for X, whatever that might be. So I wanted to point that out.
Okay. Yes, Mr. Fiorini.
Steve, the information that you provided is obviously pretty generalized. You've estimated annual costs. You've given us a range. It would be helpful to me to understand what the range was per covered action. What's the basis of the calculation? Because these numbers seem extremely high to me, surprisingly high.
We've provided a series of really two backup documents to the final number that you see in that 399 form. One is the attachment to it, and that's kind of a quick way to look and see how we got that. And then the longer cost analysis report goes through and lays out exactly those assumptions. So 10 to 25 covered actions coming forward per year is the range that we're using for purposes of illustrating the potential costs. Could be lower, could be higher than that, absolutely. And then the per unit cost is broken out depending on whether you're talking about the consistency process itself or one or more of the policies that would require the proposing, the covered action proposing agency to do something that could be costly. So that's all in that report.
If I'm doing my calculations right, 25 covered actions, that's about $500,000 per covered action.
Well, there's also costs for the council itself, and a big one of those is the priorities for levy prioritization. So there's both the state agency, the council costs, and the proposing agency, the local agency. So I'd just be careful not to layer it all onto.
That's why I'm asking these questions. I'm trying to drill down to Don's point, is that when a customer comes to a county and wants to do something, what are we estimating that costs to be on a per project basis? I'm a pretty simple guy. I need pretty simple numbers.
I mean, it's difficult. We've struggled with that. And it's going to vary a lot depending on what the covered action is. If there are no other policies that layer an additional cost on, then it's only the consistency process policy, and that's relatively small. But if they're proposing restoration or levee work or something that would then kick in one of the larger costs, which is assessment of setback levees and flood proof, some of these other more costly things, then it would be much higher. So
The largest bulk of estimated costs appear in your charts to be flood or flood protection
Yes.
related issues, because of course
that's
the delta
the
is
costly
a
part.
flood-prone area, and that
Right.
would follow
Right.
logically.
Yep.
Okay. All right, Don,
No, I don't think it's.
other questions on this?
Okay.